These are case numbers 254192 FY and 254199 FY. Appearance as counsel.
Ryan Carey for the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Dutton. He's joined me at the table.
Counsel, in both of these cases were set for probable cause conferences. Is there any resolution in either one of these?
There is not.
No, Your Honor, in file 4199. Very probably 30 witnesses. There's a critical piece of evidence that I think is going to take a very long time to get. It's the fingerprints of the vehicle to determine people are going to dismiss without prejudice, and I think Mr. Harrison is in that.
That case in its entirety, or just that?
In its entirety.
Okay, all right.
There's no sense in doing it piecemeal. And in the other file, we're gonna, I believe, set that one for prelim. We requested the video, and that may be outcome determinative once we get the video.
That's my understanding as well, Your Honor, and I've marked the sheet.
So I was making notes, Ms. Carey, so I may have missed it. In 4192, is there a request to adjourn next week's prelim to obtain the video?
It wouldn't hurt.
If I can get it, no, I don't know how long it'll take to get, but if they're willing to wait the 21 days, that give us all time to read it.
All right.
To review it.
Mr. Harrison, are you and your client waiving the 21 days?
Yes, because I think it makes sense from a practical standpoint, because if we don't have that, the video of the interaction between the officer, the trooper, and Mr. Dutton, that would certainly constitute good cause. And getting out in front of it, I think a little bit makes sense.
And that's
Just as soon have everything loaded up and ready to go before we're in a position to have a prelim or not.
and that's the resisting and obstructing case.
It is indeed.
Mr. Dutton, have you heard what the attorneys have said is happening today?
Yeah, I just heard this right now. Yes, sir.
Now, in case number 4199, that's the one with the controlled substance, the flee and elude, and the possession of an ammunition by prohibited person. Because you have been arraigned on that, you do have the right to a speedy trial. And what is proposed is that the case would be able to be dismissed without prejudice, meaning that when the case or when the fingerprints come back, presumably the case could be recharged. Do you understand that?
Yeah. So
Do you also understand that because you have been arraigned in speedy trial rights, you don't have to agree with that? You could force the case to go towards trial. Do you understand that?
Yeah. Yes, sir.
And knowing all that, then are you still in agreement with dismissing the case without prejudice so that it could be brought back in the future?
Sure. Yes, sir.
Have you had ample opportunity to discuss that with your attorney?
Yeah. I mean, I'll meet you. But yes, sir. I'm pretty confident in my decision. Yeah.
Okay.
You comfortable? Okay.
Yeah.
All right. And then in the other case, the resist and obstruct, there's a request to adjourn or essentially waive the 21 days, because if you remember from arraignment, I'd advised you that within 21 days, you would have the preliminary examination.
Yes, sir.
Now that can be waived for certain issues. And one of the issues is it appears that we don't have a video yet. And so I'm asking you, are you okay with waiving that 21 days?
Yes, sir. That's correct.
All right, fair enough.
Thank you.
So I will sign the nulli pros once I receive it in case number 4199. And then we will move forward with a preliminary examination on 4192. Now, waiver of the 21 days is going to put us on a week that we have an odd date for prelims. Prelims that week are going to be held on the 20th, so a Monday.
That shouldn't be an issue.
All right.
I don't think there's anything moving on the circuit court calendar as of yet.
Will be the afternoon, so there should
Okay.
be. So I'll make a note that we're waiving the 21 days. We're waiting a video. And we will see everybody the 20th. Anything else before we adjourn on this case?
Thank you.
Okay, thank you. Thank you. Our next call is the people of the state of Michigan versus Sonny Scott Allen.
Twice.
All right, this is case number 253956, FY Appearances Counsel.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Allen. I apologize for not rising, Your Honor. I was trying to get my computer going.
You're fine. So we are reconvening on this case after having been here on October 3rd, which was Friday. At that time, just to recap, the court's system was telling it that the plea that was entered was actually a felony as opposed to a misdemeanor, despite everybody's interpretation of that. And this is a perfect example of why we do not rely on AI, because as I said, the court wasn't clear as to what that answer could be or might be, so we ran it through AI and it came back that it could not be done. The court has since received communication from SCAO indicating that it is in fact a misdemeanor, and for some reason we have a glitch in our system. So for that reason, I wanted to get everybody back because we kind of left a hanging chad out there as to where this case was going to go. And so for purposes of what we've been discussing, I believe the plea at least was accurate as to what the punishment was. Mr. Harrison, I know you're considering whether or not there's appealable issues there for other reasons, but for the issue that the court brought up, I believe that issue has been rectified. Do the parties agree with that?
Yes.
I do as well, Your Honor.
All
I
right.
have one question. I think I can answer that myself. Picked up the wrong file twice. Sorry. Okay, no, I just answered my own question.
Okay. I wanted to put that on the record because I know we raised the issue on the record, so I want to make sure we have a clear record on this. So
I'm satisfied with that. Thank you.
anything else for the record before we adjourn this case?
No, Your Honor, thank you.
All right. Court next calls the cases of the people of the state of Michigan versus Larry Allen Mitchell II. Case number 254099 and FY and 25782 SM. Appearances counsel?
Nick Carnes on behalf of the people.
Patrick Fragle on behalf of the defendant, Your Honor.
And in the felony file, we're here for, if I recall correctly, we're here for a probable cause. And then in the misdemeanor file, a probation violation. Is that accurate?
That's correct.
Is there any resolution to either one of these issues?
Your Honor, it's my understanding there'll be a no contest plea in the probation violation file, and there is no resolution on the new file.
Mr. Fraggle?
That's correct, Your Honor.
So on the new file, is that being set then for a preliminary examination?
Yes.
Yes, Your Honor.
They set for today.
Oh, that's set for, I thought we reset it.
This is the.
Oh, that's
PV
a
is the big-
PC.
Yeah.
Sorry. That's my bad.
So we're on track then for a prelim next week. Is that still the intent?
Yes.
Yes, Your Honor.
Mr. Carnes, are you aware of any discovery issues between now and then? I realize I have your police report. but-
Yeah, I realize that too, but it's a county case. I have photos, so that's all discovery. No discovery issues.
All right. And are you aware of any witness issues?
No, I'm not aware. I suppose I should double check with law enforcement, but as far as I know, we should be set.
Mr. Fraggle, are you aware of any issues?
No, Your Honor, we're ready to go.
All right. So we will have a prelim unless it's waived next week. And then that brings us to the probation violation. And the allegations in that case are that there is a technical violation that on or about September 15th, the defendant tested positive with a PBT of a .030 and acted in a violent, threatening, harassing manner, and a non-technical violation of a domestic violence and assault by strangulation on September 16th, as reported by the Wexford County Sheriff's Department or office. And it's a plea to all of that, is that correct?
Yes, Your Honor.
Yes, Your Honor.
Mr. Mitchell, have you heard what the attorneys have said the resolution in this case is?
Yes, Your Honor.
Do you understand that resolution?
Yes.
Do you want a moment to talk with Mr. Fraggle about it? It's my understanding that you'll be pleading no contest to the allegations that I just went through for a bond violation. Now, do you understand that that violation, if I find a violation is there, you could be sentenced to what you could have been sentenced to under the original charge or what you pled to of assault and battery. Is that your understanding?
Yes, Your Honor.
Now, also, it's my understanding you're pleading no contest. And what that means is no contest is basically you're accepting guilt without saying you're guilty. So the court would read, it looks like in this case, a police report to determine whether or not you are in fact guilty of the probation violation. I would also be able to use that for the court to consider for sentencing purposes as well. Do you understand that?
Yes.
Will you please raise your right hand as best as you can? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
You put your hand down. Other than the, well, has anybody promised you anything in order to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead? And is your own free choice to plead today? Are counsel aware of any of their promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
I've been provided with what's marked as People's Exhibit number 1, which is a case number 83-250-1691, report from the Wexford County Sheriff's Office. Mr. Carnes, are you moving for its admission?
Yes, Your Honor.
Mr. Fraggle, any objections?
No objection.
Mr. Mitchell, one thing I forgot to cover is there's only certain reasons why the court can accept a no contest plea. One of those is for potential civil or criminal liability in the future. Because you are facing, this arises out of a case that you've been charged with criminally. By doing a plea this way, it allows the court to accept a plea, again, without saying that you're guilty, and then that guilty plea then being able to be used against you in the criminal case. Does that make sense? I know that's a lot of legal jumping around, but basically it boils down to this. Your plea in this case can't be used against you in the circuit, in the new case. Does that make sense?
Yes.
All right. All right, give me just a moment to review this. Council believe the People's Exhibit number 1 provides a factual basis in which to accept the plea to the probation violations and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. I do find the defendant, based on the reading of the report, did violate the terms of his probation. Just double checking one thing here. In particular, I find that the defendant was placed upon a period of probation by my predecessor, Judge Van Alst, on May 19th of this year, in which he was not to consume or possess alcohol, that he was not to act in a threatening, violent, and intimidating, harassing behavior. Additionally, that pursuant to condition number 1, that he not violate any criminal law. On a review of the police report in People's Exhibit number 1, I find that on September, in between the times of September 15th and September 16th, there was an altercation with his person who'd been in a dating relationship for approximately 6.5 years. During that time, it became physical. The report indicates that an altercation had occurred, again, in which it becomes physical. He places, although not sure which hand, did place a hand around her throat, causing breathing issues that went on for a period of time. Additionally, a PDT was administered by law enforcement that came back with a .034. Also, this happened in Wexford County. In Herring Township. So I do find the defendant has violated the terms of his probation. Counsel, I believe that because two of the technical violations essentially arise out of the same occurrence, that would be considered one technical and then one non-technical. Do parties agree with that?
Yes, Your Honor.
Yes, Your Honor.
Any objection? I'm inclined to withholding sentencing on this until we run the prelim on this case. Any objection to that?
No objection from the people, Your Honor.
Your Honor, we address, I have no objection to the sentencing, but I would ask to address bond at this point.
Any objection to that, Mr. Carnes? All right, Mr. Fragel?
The defendant has been employed with AAR for close to a year, and that's been part of his problem throughout his life, is maintaining employment. And he's done some things in the past reflecting that lack of income. So at this point, he does have a good opportunity to go back to AAR if he does so soon. The recommendation is for 30 days. He served 21. If he was released today, he would more than likely be able to get that job back. He also has made contact on his own initiative with Grand Rapids Counseling Center. We'll start him on a relapse prevention program, which he didn't have in the probation criteria at this point. And I think that'll help him tremendously. They also offer anger management on a longer term basis, as does one of the programs that the probation officer mentioned to me earlier this morning. So I think between now and the preliminary examination, he can hold his job and get his counseling in order. There will be no danger to the public or to the victim. And he's also willing to wear an alcohol monitor device, which is the underlying problem here. His testing was random on probation. Obviously, he's got, alcohol has his hook in him, and he's willing to submit to a random or a daily or a alcohol monitor device. Thank you.
Mr. Fragel, if I did modify bond, does he have a place to go?
Yes, he owns his own home, a small place in Wexford County.
Is that where this allegedly occurred at?
Yes, and he also has the support of his mother, who is in court today. She has her own business and thriving home, so he has either place to go to.
All right.
The victim does not live with him, Your Honor.
And you said the counseling services were in Grand Rapids?
Well, it's by Zoom or
Okay.
telemed. Yeah, they're very good operation. They have anger management, substance abuse, alcohol monitoring, a whole gamut, and several substance abuse counselors on staff. So,
All right. Mr. Carnes?
Thank you, Your Honor. The people would ask the court to keep bond where it's set. The underlying offense here involved alcohol and violence. The defendant was dancing and rubbing up against women in his 20s. Women asked him not to. The defendant continued, then the victim asked the defendant to stop. And then the defendant and his friend waited for the victim in the alley and beat him up, causing the victim to
Objection, Your
go to
Honor.
TC urgent care.
I think he may have the wrong case.
The underlying case, the TC's on probation.
Oh.
That's what I'm discussing. And then we have new behavior, and I know the court just read that report involving alcohol and violence. I understand what probation's recommendation is. I disagree with it. And I think that bond is appropriately set in both files. I'd ask for the remand to continue in the probation violation, bringing the bond to remain the same in the felony file. Thank you.
Mr. Pragle, any rebuttal?
Yes, Your Honor, there is a bond set in the felony file, to my understanding, that could be posted. And if he's given time served today on the probation violation, then he could post bond and begin his rehabilitative efforts. I think if we wait another week, I don't know what added value 7 days jail will have, but he will be able to perhaps keep his job and get his counseling started. And also assist in the preliminary examination. There's more to this case than meets the eye in the police report. He does have a valid defense, and he'd be able to help me prepare for the preliminary examination.
So as far as you're aware, he's, bond was set at 20,000. He's able to post that
Yes,
either through a surety bond, probably.
right.
I will, in the probation violation file, I will release the defendant on his own personal recognizance. But what I'm going to do in the felony file is I'm going to add a condition. I'm going to add a couple of conditions. I'm going to add that he be placed on GPS tether house arrest, term set by community corrections. That he not act in any threatening, intimidating, or harassing behavior. And no weapons, that he not purchase or possess any weapons or firearms. Mr. Mitchell, what that means is you're going to be tethered to a location, and you're only going to be able to leave that location under very limited circumstances, and that gets watched very closely. I take any violation of that very seriously. Do you understand that?
Yes, I do.
All right. Anything else, counsel?
No, Your Honor, thank you.
No, thank you.
All right. Thank you. Court next calls the people of the state of Michigan versus Barbara Elaine Duvall. What's the fines on the NSF?
I thought you were talking about
Appearances, counsel?
Yes, Your Honor, Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Barbara Elaine. She's next to me at the table and has joined us for court today.
And we are here for a probable cause conference. Is there any resolution in this case?
There is, I will defer to Mr. Carnes.
Yes, Your Honor. It's my understanding that the defendant will plead guilty to an added count of non-sufficient funds check, more than $100, less than $500. The people will dismiss the charged count. There's also an agreement that restitution in the amount of $245 is to be paid to Kayla Duvall.
Mr. Carnes, I'm sorry, Mr. Harrison, have you heard what Mr. Carnes said the resolution is?
I have that comports with our understanding of the events in question as well. Is that true also?
Yes.
Okay, thank you.
How will parties approach? Okay, Ms. Duvall, have you heard what the attorneys have said the resolution in this case is?
Yes, I have.
And is that how you wish to resolve it? Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Let me put your hand down. It's my understanding that you'll be pleading guilty to an added count 2 of non-sufficient fund check, $100 to $500. That is a 1-year misdemeanor, which means I could put you in jail for up to a year, and or a fine of $1,000. In exchange for that, the people will be dismissing the uttering and publishing, which is a 14-year felony. Is that your understanding of the plea agreement?
Yes, it is. Your Honor.
Additionally, there is an agreement that you will pay restitution in the amount of $245 to Kayla Duvall. Is that also your understanding?
Yes, sir.
Do you remember reading and signing the advice and rights form in this case? It talked about your rights to an attorney and your rights to a trial.
I do.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, I do. Your Honor.
Back on May 20th of this year, were you on probation or parole?
No, I wasn't.
Were you on bond in any other file?
No, I wasn't.
Other than the plea agreement, has anybody promised you anything in order to get you to plead today?
No, they haven't.
Has anybody threatened you in any way?
No, they haven't.
And is it your own free choice to plead today?
Yes, it is.
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
Nor we.
Then Ms. Duvall, to the allegation that on or about May 20th, 2025, in the city of Cadillac, Wexford County, how do you plead to NSF check 100 to 500?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on May 20th of this year, did you write a check? It looks like in the amount of, well, was it the 5,100 or was it 245?
It was in the amount of $5,100. That was the amount of loss. It gets complicated.
No, I get it. Okay. Did you write a check to, it looks like Kayla Duvall?
I did, sir.
And for purposes of the plea, would you agree that that check was between the amounts of $200 and $500?
Yes.
And were there insufficient funds in the account to cover that check?
No, there wasn't.
So the money wasn't there to cover it.
Right.
And at the time of writing that check, did you know that?
Yes, sir.
And knowing that, you intentionally still wrote that check?
Yes, I did, sir.
And was it your intent to pass that check off as a essentially good check? Do counsel believe the defendants provided the factual basis in which to accept the plea and the court will comply to it?
Yes, sir.
I agree, Your Honor, wholeheartedly.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Duvall, I find you guilty of NSF check 200 to 500. Pursuant to the plea agreement, the uttering and publishing will be dismissed at the time of sentencing. Mr. Carnes, are we able to sentence today?
Yes, Your Honor, we are.
Is this a victim input case? I don't believe it is it?
I'm not
Did a
sure.
notice go out?
The-
Don't
A
believe it
notice
is.
did go out to Ms. Starling, who was.
Okay. All right. Then-
Victims drug.
If notice went out, then I believe then that there is the opportunity to be heard. Is there any input?
No, Your Honor, she does not. I will incorporate some things we talked about into my allocation.
Fair enough. Then allocution, Mr. Harrison?
Your Honor. One of the questions that comes up in a case like this is, why did you do such a thing? Why did you attempt to, and I want to be very careful here because her daughter, Kayla, is the victim here in more sense than one, who is subject to a guardianship by Ms. Starling. So I want to be as close to the line as I can by saying to the court, it was not necessarily her intent to defraud Kayla. It was more her intent to generate some money from the bank to satisfy what were then exigent debts that she had. She owed a substantial amount of money on a storage unit that contained all of the belongings that she had possessed in the house that she had owned with her recently deceased husband. And she was on the verge of losing that. There's published foreclosure notice in the paper with regard to the storage units themselves. The house had already been foreclosed upon. And she had some desperation that was going to be the case, that all of the things that they'd amassed and any of the family items that were in that storage unit would be lost forever if she didn't act quickly. There was also a matter of perhaps what they did was they put this large check in Kayla's account and then had Kayla withdraw a couple of $100. That's the $200 restitution amount. And did some stuff for Kayla, which again, I want to be clear to the court. I'm not saying any of this was justified. I'm saying these were the acts of someone in a desperate situation who at the end of the day, quite frankly, I'm not sure what the right words or how to correctly say this. She ultimately didn't try to withdraw any more money to satisfy those other debts and things like that, because as she interviewed with the police, as they became involved in this, Starlet certainly had reason to alert them, and she did. She became very sorry. She became very remorseful. And I think she realized the folly of her situation right then and there. So while I'm pleasantly surprised that Barbara was able to accurately state a factual basis in here at court, it is consistent with the conversation she had with law enforcement ultimately, where she said, yeah, I shouldn't have done this. I've tried to come up with a way to excuse it. I've tried to explain it away, but the only explanation I can give you is that I was in a desperate situation. This is not a pattern for her. She has no prior criminal history that we were able to unearth. And I don't think it's something she's going to try again. Now, we've seen a couple of cases like this relatively recently where it kind of reminds me of the old Nigerian Prince email scam. It's too good to be true, but people blindly go into the bank and perform these transactions. And maybe the thought at the time is that it's just a bank, or it could be true, or I don't know how to explain that to you, neither does Barbara. This is a valuable lesson for her at her age to learn that no matter how desperate your situation is, if it's too good to be true, it's going to be not true more often than not. I don't see the utility in obviously putting her in jail. I don't see the utility in frankly leaving her in the term of probation here. She is on a fixed income. The assessment of any fine and court costs as well as the restitution will represent not only a significant financial burden, but a significant reminder, because she's likely to have to make payments regularly to satisfy those obligations. And I think that in and of itself should be sufficient as far as the punitive nature of the sentencing. The rehabilitation aspect of it, I don't know what more we can say or what more she can say, except that, like she did today, here's what I did. I shouldn't have done it, and I'm sorry. Thank you.
Mr. Carnes?
Thank you, Your Honor. I do recognize that Ms. Duvall was relatively cooperative with the police for this kind of resolution, taking it from 14 felony to a 1-year misdemeanor. However, this is disturbing. She essentially used her daughter, who's a vulnerable adult, to commit fraud. And while from the police report, it looks like she herself did not directly benefit from this yet, it does sound like she was hoping to benefit from it once the check fully cleared. Thankfully, Ms. Starlin caught this right away, and it did not, so that the damages are just limited to that $245. Speaking to Ms. Starlin, defendant does have a few children who are vulnerable adults, and this is not the first time there's been an issue with creative accounting that benefits defendant to the detriment of one of these children.
Is that why Ms. Starlin is appointed as the guardian in this matter? I see her nodding her
Is that
head.
how you got appointed as the guardian?
Partly, yes.
Partly, yes. So for those reasons, I do think a period of probation with conditions, I'm not sure, I'll admit this is kind of the first case dealing with this, but if there's resources for financial education, that could be useful. But really what I'm looking for here is conditions that would protect her children who are vulnerable adults. And I do have notes here from Ms. Starlin saying she ordered the fake checks and pays no rent or utilities.
Fake checks.
These were checks to a bank account in Minneapolis that doesn't exist.
So
the name of.
So there's more to it than just an NSF. We essentially have a criminal enterprise going on here.
Yes. Yeah,
Okay.
it was a forgery that was charged correctly.
The UNP was an appropriate charge based on the facts of the case.
All that being said, I am just asking for probation here. I recognize defendant has no criminal history. I'll kind of sandwich this, but I would ask the court for a period of probation. Thank you.
Having heard both sides, I think what I'm going to do, well, not I think, what I'm going to do is I'm going to order a PSI by the probation office. I'll be honest, from where I sit here today, I don't know what I can do for her on probation. But I'm going to give the probation office the opportunity to weigh in on any probation conditions if they think is appropriate. I'll be completely honest, from where I sit today, this sounds like a case that deserves a jail. We've got, I'll stop there before I dig a hole I can't get out of. So we will go ahead and set this over for sentencing. In the meantime, we'll have a pre-sentence investigation done. And Mr. Carnes, I'm going to ask that you provide the probation department with a copy of the police report.
Yes, sir.
Okay,
Anything else, counsel, before we adjourn?
nothing from me, Your Honor. Thank you.
No, Your Honor. Thank you.
Ms. Duvall, just a reminder that your bond conditions continue. Thank you.